Okay. So we will just wait for attendees to come in and get started once we've got a good group.
Okay.
Hi, everyone. We'll get started in a few minutes. We're just going to wait for a few more attendees to join us. Hello again, everybody. Just waiting for a few more people to join. We'll get started in just one more minute. Wait for a couple more people to join. Okay, I think we've got a group now. We can go ahead and get started. If Kristen, if you're still ready, I can do a quick introduction, of course, but
Okay.
I see her nodding her head. It looks like you're good to go. So thank you everyone for joining. My name is Renee Stromsky. I am a special education attorney at Albright Weicker, and welcome to the Special Education Legal Clinic. The clinic is a joint collaboration between Albright Weicker, Disability Rights Ohio, and the Ohio Coalition for the Education of Children with Disabilities, OCECD. The clinic is a free resource for parents and families. We offer our workshops on the third Monday of every month, followed by an opportunity for individual guidance sessions. This recording will be uploaded to our website after the session. Next week, I almost said next month's session on the third Monday will be on FERPA and understanding student privacy rights. So you can sign up for that the same way you signed up for today's session. Today's workshop will be from 12 to 1 o'clock and will be presented by Kristen Hildebrandt from Disability Rights Ohio, and it's on assistive technology. We will leave the last 10 to 15 minutes open for questions from the audience that you can submit in the Q&A or in the chat. And Kristen, would you prefer for all questions to be held at the end, or do you like to be interrupted with questions as they come?
I don't mind being interrupted. So if somebody can watch the questions for me and do that, that'd be good.
So I'll watch the questions in the chat. So feel free to jump in if you've got a question at all during the presentation. And then of course, at the end, like I said, we'll still have that 10 to 15 minutes open. But without any further ado, I will turn it over to Kristen for a presentation.
Thank you, Renee. Hello, everyone. Good afternoon. Today, I'm going to talk about assistive technology in special education. And I think it's one of the areas of special law, education law, that's often overlooked in the IEP process. So this presentation will tell you what assistive technology is. And also at the end, I have a section to tell you what you can do to make sure that it's something that's addressed for your child during the IEP process if your child needs that. So the the law that provides for assistive technology is the same law that provides for the IEP that your child has. It's called the Individuals with Disabilities Education Act, or IDEA. So if you hear me say IDEA, that's what I'm talking about. And that's a federal law. It's been around since about 1975, and it's the law that describes all the different services and procedures that we follow when we're serving kids with disabilities who need special education. The law defines assistive technology in a broad way, and it means really anything, any kind of item or technology or piece of equipment, whether you can just go to the store and buy it, or it's like specially made for your child, that can be used to increase, maintain, or improve your child's functioning in the educational setting. So there's no specific list of assistive technology. There are examples of assistive technology, but there's no definitive list. So really many different things can be considered assistive technology. There are a couple of exclusions in the law, and the law specifically says that assistive technology is not a medical device that is surgically implanted or the replacement of such device. And the law was, that exception was specifically targeted to cochlear implants that children who have deafness or some type of hearing impairment might have. So that is not something that a school would be responsible for providing as assistive technology. So really, assistive technology can be broadly thought of as any kind of item that supports a student's ability to participate actively in their school program. So again, it's a broad term, and so examples can be anything from a very low-tech item like those little rubber triangle foam grips that you can put on a pencil to help a child who might have some fine motor issues grip a pencil and be able to write better, which of course is something kids need to do in school, or something very high tech like an augmentative communication device for children who don't have any speech that allows them to communicate with their peers and their teachers and other staff in the school setting. So again, it's a very broad concept of what assistive technology might be for a particular child. Here are some specific examples of what assistive technology might be commonly used in a school setting. Computers and specialized software are often provided to students with disabilities who might need them. We talked about augmentative communication devices. Tablets would be considered assistive technology, adaptive switches, books on tape or other kinds of formats. Auditory equipment, like you might have a classroom where there's a child with a hearing impairment and the classroom is equipped with an FM system where the child has a headset, the teacher has a headset, and the child can directly hear what the teacher is saying without interruption from the other noises in the classroom. Standing devices like gait trainers. There might be a child with an orthopedic impairment who needs to stand up during the day, or specialized chairs, for example, that help children with orthopedic issues stay in a position that makes it easier for them to learn and access the classroom materials. Also, things like adapted buses or lifts or ramps can also be considered assistive technology. So again, this is just an example of some of the more commonly used assistive technology items that you might see in a school setting. All right, there are certain things that are not considered assistive technology, and those would be things that are personally prescribed for a particular child, especially outside of the school setting. So things like eyeglasses, hearing aids, cochlear implants, oxygen tanks, a prosthetic arm, and braces are all things that courts have considered to be outside of the scope of assistive technology that a school district would be required to provide to an individual child. So if it's something that somebody prescribed outside of the school setting, it may not be assistive technology, okay, in the school setting. So just know that there is an exception to certain pieces of equipment. All right, so what are the benefits of assistive technology? Well, the assistive technology can help kids participate more actively in their school and community activities. And we'll talk later on in this presentation about the times during which a child would be able to take assistive technology that's provided by the school district into other settings, like into the community, for example, and at home. We'll talk about that. Benefits of AT can also help kids play successfully with toys and other children in the classroom, particularly for younger children, where play is a big part of the educational program. Learning how to play and use imagination and interact with other children and take turns. Assistive technology can be very, very beneficial in that regard. Lots of times, assistive technology is provided because a child doesn't have the ability to communicate well with peers. They might be nonverbal, or they may have other communication deficits that make it very difficult for them to communicate. So assistive technology can help with that. It can help kids make choices if they are unable to verbalize their choices. Certainly there are many different kinds of assistive technology that would allow a child to communicate, like a communication board or a button where they can make choices. And then lots of assistive technology benefits kids with orthopedic impairments so that they can move more independently throughout the school building. They can get around a building that may not be completely physically accessible with the use of ramps and lifts and things like that. So there is a wide range of benefits for assistive technology in the school setting, and that's why it's so important for you to know about the availability of these types of equipment, and also other kinds of support services that schools have to provide when a child has a piece of assistive technology. So the IDEA, the federal law, requires school districts to do certain things around assistive technology. And the first thing is they have to consider the need for assistive technology for every child. They have to evaluate the need for assistive technology. If a school team, an IEP team, determines that assistive technology is required for a particular child, it must be provided to that child at no cost. Why? Because the IDEA provides what's called a free appropriate public education. And so schools cannot charge families for assistive technology because that would violate the free component of a free appropriate public education. And then the school has to provide individualized assistive technology to a particular child. So they can't have a one-size-fits-all assistive technology library, for example, and they say you can use a piece of equipment from this particular library. It has to be an individualized determination based on the unique needs of that particular child. All right, so who can get assistive technology? Well, as I said before, the need for assistive technology has to be considered for any student with an IEP. And in fact, there is a place on the IEP form that guides the team in making that determination. Unfortunately, what we see a lot in our practice is schools kind of glossing over the question of assistive technology. When they get to that part of the IEP, they might just say, oh, this child doesn't need assistive technology, and the team moves on. There should be a much more robust discussion about whether or not a particular child needs assistive technology. And certainly, if a child has communication needs identified in the IEP, or behavior needs, or orthopedic needs, or the need for occupational therapy or physical therapy, that is a signal that that child should be considered for assistive technology and may in fact benefit from a lot of different items that could be provided in the school setting. Now, this presentation is going to be almost completely focused on the IDEA, the federal law that provides for an IEP, but I do want you to know that there are a couple other federal laws under which a child could get assistive technology if they don't have an IEP. And those laws are the Americans with Disabilities Act, specifically Title II of that act, the ADA is what we call it, requires schools to make sure that kids who have disabilities have equal access, accessibility to the program that's offered by the school. Another federal law is the Rehabilitation Act of 1973. We call this Section 504. You've probably heard that term before, because that's the section of that particular law that covers education in schools. And you might have heard of kids who have a 504 plan. So under the Rehabilitation Act, for children who have 504 plans, who are otherwise covered by that law, they may be able to access assistive technology as well. Under the ADA and 504, schools are required to provide students with disabilities equal access to educational benefits. And so when you think of the term educational benefits, that means really everything that the school provides in their educational program. So that includes curriculum, it includes specials, it includes access to different parts of the school building, it would include extracurricular activities, anything really that the school provides to students that go there and their parents would be covered under these particular laws, the ADA and 504. So this can include things like access to whatever technology the school district is providing to all of the students, maybe ebooks or book readers or screen readers or online instructional material. So since the pandemic, a lot of schools have provided their instructional services through online software and materials. So in that kind of a situation, if a school district is still doing that, for example, if a student with a disability cannot fully access what the school is offering, they then might be eligible for some assistive technology that helps them access the services provided by the school district. Title II of the ADA also requires schools to ensure that their websites are accessible, not just to students, but to staff members, parents, and visitors, right? So there are opportunities for accessing assistive technology in these other federal laws. To achieve compliance with these laws, districts have to ensure that whatever technology that is accessible to students with disabilities or provide them a different way of receiving the same benefits, right? So if a school has some kind of an online program, but it's not accessible to a child with a disability because they have a visual impairment, for example, the school must provide some kind of assistive technology that would allow that visually impaired to access that online instruction. Now, districts aren't necessarily required to provide kids with disabilities the same devices that they assign to kids who don't have disabilities, as long as that child with a disability can receive all the educational benefits that are provided by the technology that they give kids without disabilities in an equal and effective way, right? And in an integrated way. So they have to be able to access it in the regular education classroom if that's where they are, alongside their peers who don't have disabilities. And then the other thing about Section 504 in the ADA is that the school does not have to provide assistive technology that a student uses outside of the school. So it's kind of similar to what we talked about personal devices or specifically prescribed devices for students. Things like eyeglasses, hearing aids, those kinds of things. Those are considered services of a personal nature and specifically prescribed for that child, and that ADA 504 also do not require a school district to provide those kinds of things. So in addition to actual assistive technology, the device or the piece of equipment or whatever it is, a school is also required to provide what we call assistive technology services. And those are anything really that directly helps that child with a disability select the appropriate assistive technology, get the assistive technology, and use the device in the school and other settings where the IEP team determines that child will be using that piece of device. So they are supportive kinds of services that make sure that a child gets the equipment and knows how to use it. And it's maintained in a working fashion. Assistive technology services include Evaluating the need for assistive technology. So it requires the school district to do an actual evaluation for a particular student to see if they need assistive technology. The services also include buying the AT, leasing it, or providing it. So there are options for a school district to straight up buy a piece of equipment. There are also entities that will lease assistive technology to school districts that they can use and then return, and making sure that that student actually has that assistive technology. It also includes selecting, designing, fitting, customizing, adapting, maintaining, repairing, or replacing AT. So it's a very broad service that makes sure that when that student gets the assistive technology, it is specifically designed for that student and their unique needs, and that if it breaks, it's repaired, and the student has always has access to the assistive technology that was deemed to be necessary for that child. It includes coordinating and using other therapies and interventions or services with assistive technology. We often see kids with AT who need an occupational therapist or a physical therapist or a speech therapist. So an example might be that a child gets a nonverbal child gets an augmentative communication device. The speech therapist at the school and maybe even the occupational therapist at the school help to make sure that the child knows how to use that device, can access it if there's a physical limitation. And those people work together to make sure that the appropriate services are coordinated so that the child can effectively use the device. And services also can include training or technical assistance for the student who has the assistive technology, the family members, if they need to know how the piece of equipment works. Going back to the augmentative communication example, if a child is nonverbal and they're using augmentative communication and they're taking that device home, then the family needs to know how to use it and to help that child use it to communicate with the family. It could also include training for school staff, employers, or other people involved with the student. So if we're talking about an older transitioned aged student, perhaps using a piece of assistive technology in an employment setting, then the AT services could include training for an employer and technical assistance for those employers as well. So where can a student use assistive technology? Well, obviously all areas of the school. So that would mean every area in the school, the physical building of the school where other students are accessing services or pieces of the program. School transportation. So if a child needs to take assistive technology on the school bus, they should be able to do that. Assistive technology can also be used in standardized testing. So if a child is going through a state test, for example, and they need their assistive technology to access the test, might be an online test, then they should be able to do that. It can also be used in the community. If a child needs to go out into the community for purposes of the school program. Kids go on field trips. For older children, they might be going into the community for some job experiences, or a student might go out into the community to learn specific skills, for example, like shopping, using money, that kind of thing. And if they have assistive technology that they need in the community, they should be able to take it with them. And again, students who need to should be able to take their assistive technology home. If a student has a piece of assistive technology, then the IEB team really needs to have these kinds of discussions about, where is it going to be used? Does the child need to take it home? Does it need to be taken on the bus? All of those things need to be addressed and considered by the IEP team when they make a determination that a child needs assistive technology. Okay. So it really needs to be used in all settings of the school program where the student needs it to access the program. And again, under IDEA, under ADA, under 504, the whole point of assistive technology is access, right? Is accessing the program as fully as students who don't have disabilities can access it. So that's sort of the standard to be applied when a team is making determination about where it should be used. And then once the team determines how and where the AT will be used, that needs to be detailed in the IEP somewhere, right? So that everybody understands where the child is going to be taking the assistive technology, and there aren't things don't come up, right? Like a child takes a piece of equipment into a regular ed classroom, for example, and the teacher doesn't know about it, or doesn't understand why the student has it or how it's to be used to access the program. So that's why it's so important for the team to make all those determinations and make sure that the IEP clearly details the breadth of the use of the assistive technology and where the student will be using it. Okay. In terms of taking assistive technology home, this is an area where a lot of disputes come up between parents and school districts. But the decision about whether the student is going to take the assistive technology home has to be made by the IEP team and must be based on the student's individual needs and circumstances. So what would be a violation of the law is for a school district to say, if we bought the AT for you, you're not allowed to take it out of the school building. And I've had cases where schools have raised all sorts of concerns about what if it gets broken, and who is going to be liable for fixing it, and if you don't have insurance on it, you can't take it out of the building. That's not, that is not appropriate under IDEA. If the IEP team has determined that a child needs to take their assistive technology home, then that needs to be in the IEP, and the team has to determine how that's going to happen, right? Like how is it going to be protected when it's being transported? All of those issues should be addressed by the IEP team. But it's clear under the law that a district can't have a blanket policy prohibiting that. So they can't say, we don't let students take the AT home. It has to be an individualized determination based on what's appropriate for that particular child. So who maintains the assistive technology? What if it gets broken? What if it's in transport and it gets broken? Or what if somebody drops it? Or what if the student throws it? Which, I've had cases where that's happened. The law requires the school district to be responsible for that. So they're responsible for maintaining assistive technology in good working order, fixing it if it gets broken. And if it's something like an augmentative communication device or computer, something that's more complex, they're also responsible for making sure that it is programmed and working accordingly. That's another thing that the IEP team should address, right? So how often does it need to be reprogrammed? And who's going to make sure that it's in good working order, it's doing what it's supposed to be doing. The school district is responsible for that. And again, that should be addressed by the IEP team, and there should be some clear guidelines about how that's going to happen. What about the cost of assistive technology? So we've had cases where school districts have said, oh, we can't provide this because it's too expensive. Right? Well, the law says that's not an excuse for not providing appropriate assistive technology. So the cost of it is never an excuse for a failure to provide assistive technology, right? However, because some of assistive technology can be very, very expensive, the law does say that a school can provide the cheaper option if they can find a cheaper appropriate option. And the standard is it has to be appropriate. It has to do what the student needs it to do. So again, augmentative communication is one of the most expensive types of assistive technology. So if a team can identify 2 augmentative communication devices that are appropriate for that child and give that child equal access to the program, then they can provide the cheaper of those 2 appropriate options. They can't provide a cheaper option if it's not appropriate, if it's not going to work for that student. So also, a school is not required to provide a parent's preferred assistive technology as long as what they provide is appropriate. So a parent can tell the IEP team what they think is the appropriate piece of equipment, but if a school district can find one that is also appropriate, that is cheaper, or one that they just like better, or they think will work better in the school environment, they can do that. Right? As long as it does what the child needs and it's appropriate, the school can choose which one to provide. All right, so AT, as I said earlier, can be used during standardized testing. Certain assistive technology can be used during like state tests, but the IEP team should determine what is appropriate to use, and if it's going to be used during testing, it should be documented in the IEP. Now, there may be certain circumstances where the use of a piece of assistive technology would be prohibited by the state's rules around accessible state testing. A good example might be a calculator. So a calculator could be considered a piece of assistive technology, but if a child's being assessed for their ability to do calculations, then in that particular portion of the test, a calculator may not be appropriate because the test would then not be testing what it's trying to test. There is a manual that the Ohio Department of Education has put together. If this is an issue that you are looking at for your particular child, called the Ohio Accessibility Manual for Ohio State Tests, you can just search for that in the Ohio Department of Education's website. It will come up and it will give you guidance about what can and cannot be used in state testing specific to assistive technology. There are, as I said before, a school can either outright buy a piece of assistive technology, or they can borrow it, or they can lease it. There are lending options, and this is important to know because sometimes it's trial and error to find the right piece of assistive technology for a particular child. So again, under the augmentative communication umbrella, there are multiple different kinds of devices that do similar things. And it's important to make sure that a child is able to test the use of a piece of equipment or trial it to see if it works for them. It might not be physically easy to use for a particular, one device might not be particularly easy to use. So it's important to be able to trial these things. And there are places that will let school districts borrow items for that particular purpose. So there is, I put a link in here that is a really nice guide to assistive technology lending libraries. If you're trying to get something for your child and the school doesn't know where to get it to maybe trial it, there are these places that will do that. And that's something that you can provide to your school district if they don't know about it. But again, it's good for trialing purposes, but it's also good if a school district wants to just, doesn't want to purchase an expensive piece of equipment until a student has had, a longer period of time to use it in the classroom to see if it actually works. So I want to talk a little bit about things that you can do as a parent to make sure you are doing what you need to get any necessary assistive technology for your child. Yes.
And can I interrupt you for a few questions quickly?
Yeah.
We have a few from the audience. The first one is, would a digital reminder watch or something like that be considered as assistive technology?
Yes.
That's what I thought too. And the next question is, if a student has in the IEP an accommodation to use a calculator, but in section 2 of the special instructional factors of the IEP, it says, does the child need assistive technology devices? And the answer is marked no. Would that need to be changed?
Oh, that's a complicated question. Maybe. I mean, it technically is considered assistive technology, but I guess it kind of depends on its use. I don't know. I think probably yes. Technically, it would be considered assistive technology. I think what happens a lot of times is school districts don't consider a calculator to be assistive technology because it's such a commonly used device in the classroom, and it might be that like every kid in that classroom is allowed to use one. So it kind of depends on the facts, but technically I would say yes.
That's what I was thinking, is that it is technically an assistive technology device. It's been around for so long that
Yeah.
we don't even see it that way.
Yeah, and that's what happens is we don't really consider it to be assistive technology because it's so commonly used in the classroom.
And then we have one more question, and I'll let you get back to your presentation.
Yeah.
And this one is, how and when is a communication device a personal device to be funded through the child's insurance versus the school?
Okay, so so here's the answer. The answer is that a school district is always responsible for paying for that kind of device if it's necessary to access the educational program, right? But what happens in reality, because I always say there's the law and then there's reality, is that you might be living in a very small rural school district, right, that really is struggling financially. And they ask you if you can provide the device. And if a family wants to provide the device, they can do that. Like if they have good insurance and the insurance will pay for the device, a family can do that, right? If they want to do it, but a school district can't force them to, right? So there are situations where a family has already gotten a device through their private insurance or Medicaid, and the school district is struggling and they just say, well, we'll just use our device. You can, and they take it to school, and that's what happens. But families need to understand that that's a strictly voluntary kind of a situation. And if something were to happen to their device and the student needed it in school, then the school would have to get one, right? So I hope that answers the question. It's a, you know, it's a situation that I see kind of regularly, but parents need to know that it's truly at their own choice. They volunteer to do it. And if it's something ever comes up where they can't volunteer anymore, the school needs to step up. Okay.
That sounds good. I think that makes a lot of sense, especially in terms of as long as it's for, accessing the education, the school's obligated to provide that.
Yes,
Thank
absolutely.
you.
Yeah.
And I'll let you continue with your presentation too.
Okay. Okay. So let's talk a little bit about what you can do as a parent to make sure that you are, thoroughly discussing the issue of assistive technology. So the first thing that you want to do is make sure that the IEP team has a discussion about assistive technology. So I said earlier in this presentation that a lot of teams just kind of gloss over that part of the IEP. As a parent, if you think your child needs assistive technology, don't let them gloss over that part of the IEP, and ask them to have a thorough discussion about whether your child needs assistive technology. And now that you know how broad that term is, if you can think of some things that your child might need to access the program, raise those with your IEP team. If you have any private evaluations or recommendations for assistive technology, make sure you share those with the IEP team and ask for them to discuss the recommendations and how they can be implemented in a school setting. So there are kids who have orthopedic impairments, for example, they have private PTs or OTs, or they have private speech therapists. And you can have a discussion with those people about whether your child would need some assistive technology in the school setting. And if they think they do, ask them to put that in writing and share it with the school. You can request an assistive technology evaluation from the school. So the first step really in determining AT is evaluating that child's needs. So ask the school to do that evaluation. And there is a specific right in IDEA to something called an independent educational evaluation, or IEE. And that's available to parents anytime they disagree with an evaluation that the school district has conducted. That might be a full multi-factored evaluation or initial evaluation to determine if a child's eligible for an IEP. It might be a functional behavioral assessment if the child has behavior problems. It might be a PT evaluation, an OT evaluation, a speech evaluation. But that right is there anytime you disagree with an evaluation that the school has done. And it's if they've done an AT evaluation and they say your child doesn't need AT and you disagree, you can seek this independent educational evaluation. There are specific parameters around getting one of those. So if you think you want one, you want to ask the school districts for the for their policy on independent educational evaluations, and maybe reach out to an advocate about what kind of strategy choices to make when you seek one. Ask for assistive technology trials, right? So if you think your child needs something and you're not sure what, ask your school to borrow equipment or devices or whatever it is, and do some trials and collect data about how your child does using that particular piece of equipment. Data about how the child can access the AT. Is it easy to access or not easy to access? Do they actually use it or do they not use it? Do they understand how to use it? Is it helping them? All those kinds of data points should be collected. And then you want to ask for AT services. So if the team determines your child needs some kind of equipment, make sure the team also talks about what kind of training will be necessary for the student, for the parent, for teachers and other school personnel that are working with that child and that piece of equipment. Make sure the AT is written into the IEP in detailed fashion so that everybody on the team understands how it's going to be used. If your child goes into regular education classes, that the regular ed teachers understand how it's going to be used and know how to help the child if the child's having problems. The IEP should describe where and how the AT will be used, including different areas of the school, whether it'll be used on the bus, whether the child will be taking it into the community, whether the child will be taking it home. All of that should be detailed clearly in the IEP. And if there's no space in the IEP, write up a separate AT plan and attach that as an addendum to the IEP. So it's just critical that everybody is on the same page and is very supportive of the student in using the AT. Because if a child has a piece of equipment and staff are not supportive and it's not going where it needs to go, they will stop using it. And that will impact their ability to access the program. The IEP should include assistive technology goals and objectives, particularly if a child is learning how to use a piece of equipment. Augmentative communication is another good example, right? Those are things that need to be learned, how to navigate around the programs in the device, how to find what you want to say. And so there can be goals and should be goals and objectives that help that student learn how to use that device in the school setting. Parents should ask for ongoing support from the assistive technology manufacturer, particularly with more expensive AT. The manufacturers typically will have people who are assigned to a particular school that help the school if there's any issues around the way the device is functioning. They have people who can help train staff and kids on how to use the device and navigate around the device. So know that that is almost always something that's available from the manufacturer. You can seek support from organizations that assist schools with the issue of assistive technology. One of those organizations is called OCALI. It's the Ohio Center for Autism and Low Incidence. Those are low incidence disabilities like TBI, for example. And OCALI has people who are very educated in assistive technology and then can help school districts through the process of evaluating and figuring out what kind of assistive technology is appropriate for a particular child. And then you want to make sure you designate a point person for issues that arise. So this is actually good in a lot of issues in special education, that the IEP should designate a point person for particular things, right? So designate a point person on the IEP as the AT person who a parent you can go to if an issue around the AT comes up. That might be the speech therapist if it's an augmentative communication device. It might be the OT if it's some kind of orthopedic device. It just really depends on who that person is, but designate somebody so that they know they're responsible and they're paying attention to what's going on and they're on top of any issues that come up. All right.
Thank you so much, Kristen. I was just about to ask you another question too, which is perfect. But thank you again for your presentation on assistive technology, because I know I learned some things that were really
Good.
helpful. The question that we have right now is regarding supply chain issues, which are an unfortunate, very real thing right now. And it's more related, and I was going to say you probably can see the question now too, but if that personal device or that assistive technology device, what happens if it's broken? And if it's the insurance that covers it or the school? And then there's a more specific part of that question as to, okay, so what happens when that assistive technology device is broken and we just because of supply chain issues, we can't get it? What is the school doing during that time?
Right. So the first part of that question is that the school district is responsible for fixing broken devices. Now, it can get a little bit complicated if it's the scenario where it's the parent's device and they have volunteered to use that in a school setting. Technically, I think the school is still responsible for getting that fixed. But again, the reality is that sometimes they might not have the money or what, and it might be that it's Medicaid purchased and Medicaid, it's just complicated. But clearly, if it's a school purchased device, they have to get it fixed. The supply chain issue, my best answer to that is to use the resources available in the lending library. So we talked about that there are places that have AT devices that they can loan to school districts. So if the device can be found in a lending library, that's often a good way to sort of fill that gap when the device is broken and needs to be sent back to get fixed, and there's some period of time before it's coming back. So that's a good option. Another one is to reach out to the manufacturer. So if it's an expensive device, like an augmentative communication device, you can reach out to the manufacturer where the device came from and ask them if they have a loaner that can be used while the device is being fixed. So those are a couple of ways to try to make sure that a child isn't without their device for a long period of time.
Thank you so much. And I think part of that too is that part of the question was, is the school required to transport the child in the interim? Because the assistive technology device was more referring to a wheelchair for this specific example. So that would be, if whatever piece of the wheelchair is broken that now not allows it to go on the bus to school, would the school still have to transport the child in the interim? I would say yes, just because even if they're not able to, this child is still entitled to that transportation. And realistically, even if they weren't able to be transported there, they would still be entitled to that, any compensatory education that might come from missing school because of missing transportation. And
Yeah.
Krista, you might, yeah.
Yeah, you're absolutely right. However, I will say that in some circumstances, it might be extraordinarily difficult, right? If you have a child who is medically fragile, for example, and has a very specialized wheelchair, and you can't just take that kid out of the chair and put him in a seat, and get him to school. It can be extraordinarily difficult. But the school, yes, has to try to figure it out, right? They have to make best efforts to figure out how to get that child there, using other means. And if they can't, if it's absolutely impossible, then yes, they would then have to figure out how to provide services in the home until, like home instruction, for example, where somebody goes to the house to educate the student until they can get the student back to school. And in that kind of scenario, what often happens is the school says, okay, we'll just do home instruction. I'll give a child an hour a day of a tutor. That doesn't cut it, right? So the team really has to figure out, how are we going to make sure that whatever we do at home is as comparable as it can be to what's happening in school, including, the provision of related services like OT, PT, and speech. And how are they going to, provide the socialization aspect and all those kinds of things. So maybe they do like an online, maybe the kid participates online and sees what's going on in class, and then the related services people go home. But yeah, they have to make their best efforts.
Yeah. And there's a couple more questions too. And what I should say now that to our audience, of course, our presentation is over now and we are opening up the Q&A for audience questions. So feel free to submit those in the chat or the Q&A. The next question is, if the school brought up the idea of a reminder watch for the IEP meeting for the parent to purchase for their son, is the best approach for the parent to go back and ask for the school to provide it for them as an assistive technology accommodation?
I think that kind of just depends on the situation in terms of best approach. I think certainly if the school brings it up, yes. I mean, I think a parent should say, I think that's a piece of assistive technology. Let's have a discussion, a robust discussion about is that necessary for my child to access the program, stay on track, get from class to class, whatever it's being used for. And if it is, then yes, the school should be, paying for that device. The thing about assistive technology is, if the school buys it, they keep it, right? So let's say your student is in 11th grade and the school buys the watch and they use it for 11th and 12th grade. When they graduate, let's say they graduate, then the school keeps that watch, right? It doesn't stay with the student. So those are all the kinds of things that you have to think about when the school is purchasing the AT. Like, right, how is that going to affect the student? Like, let's say you've got a 12th grader, they're going to go on to college, the school buys the watch, they're going to need the watch in college, and then it doesn't go with the child. So those are just all the things to think about, with the understanding that it's always the obligation of the school to buy it if the family doesn't want to or can't or whatever. But there are situations where parents choose to get those things either through Medicaid or private insurance because they know it will follow the child when they leave.
That's really good insight to have. Thank you. I didn't think about, I didn't even think about after school, of course, when they're graduated, what happens.
Right. And it's less of an issue when you have a little kid. If you're talking about a 5-year-old, right? Let the school buy the device and the kid has it for forever. Oh, the other thing to think about too is, like, kids grow and they change. So if the school buys something, that should be reassessed on an annual basis. Is this still appropriate assistive technology? Do we need to get a different model? Do we need something else because a child is growing or the program is changing? Like when they go from elementary to middle school, there are things in middle school where the current AT is not cutting it. So those are things also to think about and keep reassessing it.
The next question is, would software to improve on auditory processing disorder ordered by an educational audiologist be considered assistive technology?
Yes.
The school district says they don't have to monitor progress on the software because the child is overall progressing in school, but no one at the district is an expert in auditory processing disorder.
Okay.
But I know Oh, I was gonna say, I know a lot of schools like to use the progression from grade to grade as evidence that a student doesn't need an IEP in general or certain accommodations. But as we know that
excuse always makes me laugh, right? Particularly with AT, right? It's because the student has the AT probably that they are progressing, right? So yes, we need to monitor it, make sure that, we're collecting data about its effectiveness and all that stuff. So yeah, I mean, that's just, I don't understand that. I don't understand that kind of thing from a school district, honestly.
Yeah, I see that a lot, unfortunately.
I've never understood that. Just like I've never understood why the response to behavior is to kick a kid out of school. Don't understand. Don't understand that. Just does not compute.
I know. Another question we have is there an assistive technology or an assistive technology device that would help a student with ADHD on the Chromebook at school? For example, with going on multiple sites not related to the class or present topic. So maybe just focusing on the Chromebook.
Yeah, I don't know the answer to that question. I think the answer is that a parent should raise that question and ask the school district to assess whether there's something that can be used to help that situation. I can imagine there's got to be some kind of monitoring software or something, right, that at least could document how frequently a student is going to the wrong places, and the team could collect that data and then figure out how big of a problem it is and figure out a plan to address it. So I'm just not not a techie person. I can imagine there's stuff out there, but the answer is ask the school to assess what's out there
Mhm.
that might be used to help.
Yes, absolutely. Next one we have, and thank you everyone for so many questions, and we appreciate it. This is, can you speak a little bit about wheelchairs in the school, specifically as it relates to a child learning to move independently in the school environment to engage socially and in learning versus an aid moving the child from place to place? How can this best be advocated for parents and therapists, and what does the law say?
So I think the answer is, again, I'm not an OT or a PT, I'm not a specialist in that kind of stuff, but I think the answer is that one of the central tenets of IDEA law is that we want kids to go through school and be as independent as possible when they graduate, right? In as many ways as possible. So the whole point of school is to give kids skills to make them independent, employable adults, right? So part of that is being independent in moving around and accessing the environment and getting from here to there and being able to make individualized decisions about where you're going and when, right? So it's just that idea of, the whole basis of special ed law is to create independent adults, graduates. So that's what I would use when I would be advocating for my child, for access to the program, independently, physical access. That's your argument, right? Everything that we are doing is to make that child independent, and that's why that child being able to move themselves around the environment themselves as opposed to having an adult push them around is important. Also, I don't know where your child wants to go, but if they want to go, for example, to college after they graduate, there's not going to be an adult pushing them around in college because the standards are different there. So if your child is headed towards college or headed towards competitive employment, you need to reinforce with the IEP team how important it is that your child's not relying on adults to help them do things. I mean, to the extent that they can be independent, they need to be, because that will make it more likely they can be independent in college and in the community, a competitive job, wherever they're going. That's the big argument to be made.
And I'm thinking too, it could be maybe even an IEP goal is that she's working toward independence away from using the wheelchair. And that way it's more framed, and it's more framed for the school district to collect that data. And then it's more again, it's that natural goal toward a transition toward independence.
Yes. Yeah. And the older a child gets, the stronger that argument becomes, obviously, because then we're into transition planning and, all that.
Yeah, exactly. We have one more question right now. We have a couple more minutes though, but the question we have is the need to use an elevator considered assistive technology? Our middle school has allowed use with a key fob and we are headed to high school next year. Should I have that added into the IEP as an assistive technology device?
Well, so the actual, the elevator itself is just an accessible component of the building. But if there's some way for that child to access that computer independently, like the key fob, like some kind of electronic device or something, I suppose that could be considered assistive technology.
But I would think use of the elevator, at least, again, just in general as an accessibility feature, would be something that you could put
you would
into
add
the
that.
IEP.
Yes, you would definitely add that to the IEP.
And let me see, I don't see any more questions right now, and haven't in a while, but we've had 9 questions, which is awesome. I don't see any more coming. Oh, I have one. We'll answer our last question. I'll say this is our last question. If anyone else has any further questions, put them in. If I don't see any, this is our last. When a kindergarten or elementary school child has mobility issues and cannot engage in recess, how can this be accommodated? And that, I was just going to say that again, that would be something that would be an evaluation just to see what kinds of what different ways they aren't able to engage, to assess what ways they can be accommodated or service to be engaged at recess.
Yes,
But yeah.
yeah, that certainly that would be great. The other thing to know is that the federal law requires, like the ADA and 504 that I talked about, requires all portions of the educational program to be accessible to kids with disabilities, right? So you can ask for the school to do an assessment of the accessibility of the playground and to make it accessible. Now, again, here's a good example of where the law and reality go boom, right? Because an accessible playground is like $300,000 or $400,000, right? And that is going to be it's going to be difficult for many school districts, but the law says you need to make it accessible. So I would ask the team to discuss it, and then I would ask them to do an assessment of what the child can and cannot access. There may be some easy things that can be done, like you can put, like if the playground is mulch, you can put down these heavy rubber mats where a wheelchair can get access to equipment, that kind of thing. But again, it starts with the discussion at the IEB team and the request for the assessment about what the child can and cannot do and how it can be accommodated. And it might involve some assistive technology. I don't know.
Yes, I was going to say it always might.
It might.
And we don't have any more time or any more questions anyway. So I wanted to thank Kristen for her wonderful presentation today, and thank everyone for coming as well. Our next special education legal clinic is on February 20th, I believe, the third Monday, and that will be a presentation on FERPA and student privacy rights by Albite Weicker. Kristen, did you have anything in closing? No,
I didn't. I'm glad. I'm happy that people had a lot of questions. It's always nice to have it more interactive.
Absolutely. Well, thank you guys so much for attending. This should be within the next week. It should be on our website, the recording, and we will see you all next month. Take care.
Bye.